Hi everybody, it's Andy, and welcome again to my office in Los Altos, California. I'm an attorney licensed to practice law in California as well as New York. This video is going to be a really quick primer, I guess, on California community property. So, community property in general is going to be the framework within which California will divide the property that is acquired or owned by two parties in the event of a divorce. So, for example, husband and wife, when they're married, they acquire a bunch of property. When that marriage ends in divorce, community property will determine how the courts will divide that property. So, community property right now in the United States is used by approximately 10 states, predominantly concentrated on the West Coast, so Pacific time zone. If you are one of my New York viewers, for example, equitable distribution actually is what applies to you. So community property does not apply to you. Equitable distribution is the schematic instead. So I don't have it yet, but eventually I hope to have a video on New York equitable distribution. And when I get it, I'm going to go ahead and link it right over here. So if you see a little annotation bubble pop up, that means I actually got around to recording it. So, but the general idea is going to be that anything acquired by a married couple from the date they got married to the date they actually separate, that's going to be community property. And in the event of a divorce, that stuff is generally going to be divided 50-50. So the thing is, it can also be kind of modified slightly, 60-40, etc., depending on the situation, but 50-50 should be the general rule. The definition of community property is going to be in California Family Code section 760, which I am going to go ahead and link and paste down below. So go ahead and take a look at that if you are so interested. So the flip side of the coin is going to be separate property. So separate property is going to be defined in California Family Code section 770, which I'm also going to go ahead and paste and link down below. But the general idea is going to be that anything acquired by either spouse before they got married, so the thing is, let's say husband owned this guitar before, or wife owned this, road bicycle or something, that stuff is going to be the separate property of that spouse. And in the event of a divorce, the husband gets his guitar, the wife gets her, road bike, etc. So that is kind of the most common, I guess, or general separate property situation. There's also some situations in which a spouse, so let's say the husband, acquires something by gift or inheritance. That's also going to be separate property, even though it happened between date of marriage and date of separation. Same thing for the wife. If the wife receives something during the marriage as a gift or as an inheritance, that's going to be separate property also. And in the event of a divorce, the wife will get whatever she inherited by the wife will get whatever she inherited or received by gift, and same thing with the husband. So that's kind of a very simple way of describing it. So that's stuff that's entirely community, stuff that is entirely separate. The problem usually comes up if there's something that is partially community and partially separate. The most common example that I run into is actually a house. So I'll give you this kind of situation. Let's say, for example, that the husband bought a house on his own when he was still single, and he pays his mortgage for a couple years, and then maybe, say, 5 or 6 years in, he decides to get married, and after the marriage, the husband and the wife together pay the mortgage out of their earnings. So in the event of a divorce, that period for when the husband paid the mortgage on his own, that part is separate. After he got married and the wife and the husband together paid for the mortgage, that part is community. So the battle in a case like that, if there is a battle, is going to be how to determine what percentage is community, what percentage is separate. So hopefully that made sense. That's a really basic kind of overview of community property law. There's stuff that is entirely community. There's stuff that's entirely separate. There's also property, or assets rather, that are a combination of community and separate depending on the situation. So hopefully that helps. If you are outside of California or in a equitable distribution state, hopefully all of that made sense. But if you're in California, hopefully that helped you if you're facing a case where community property is a thing that you guys are fighting about. So like I said, hopefully that helps, and I will talk to you guys next time. Thanks.